Mr. Loughlin.
Please, the Court. The Court has the appearances as they appear in the respective cases of the parties. Lord, there is one issue before the Court, and it concerns the nature of the ministerial discretion under Section 13(1) of the Inquiries Act 2005. Can I regrettably begin, however, with one piece of housekeeping? The amendment to the Order 53 statement that was granted by my Lord Mr Justice Colton doesn't appear in the papers. It's been added recently, but the Court will find it in any event reproduced faithfully in paragraph 13 of the Court of Appeal's judgment at EF 187. That's EF 187, paragraph 13. There are 5 potentially relevant documents in relation to this issue. I'm going to ask the Court now to look at one of them, but I'll go through them. The first is the Solicitor's letter to the Minister of the 16th of June 2022. That is at EF 312. Secondly, the Minister's reply of the 29th of June, that's at EF 316. Solicitor's further letter of the 7th of July 22, EF 599, going into EF 600. The Minister's reply to that, fourthly, of the 9th of August 22, that's at EF 598. And then in the advice to the Minister of the 27th of June 22, we see the specific advice that was given to him that really forms the basis of this challenge. And that begins at EF 1004, paragraph 9. And I'd invite the Court to turn that up. So at paragraph 9 at the very bottom of EF 1004, the Minister is briefed. The Minister has a discretionary power under Section 13 of the 2005 Act to suspend an inquiry where it is, in scare quotes, necessary to allow for the completion of a criminal investigation over the page or criminal proceedings arising out of matters to which the inquiry relates. The Minister must consult with the Chairman of the inquiry before the power is exercised. So the question central to this appeal really is the Minister able to suspend an inquiry to allow for the completion of specified investigations or of civil or criminal proceedings without having to be satisfied that such a suspension is necessary? To concretise this a bit, is the Minister, for example, able to suspend an inquiry because he thinks, for example, that another investigation will secure relevant information more quickly, more cheaply than the inquiry, and that it is desirable, but not necessary, to obtain that information and avoid expensive duplication? We suggest that the answer to this question is yes, and that Section 13(1) limits the period of suspension to the period considered to be necessary for the completion of the specified proceedings or investigation. So, for example, to exaggerate the point, the Minister cannot suspend an inquiry for a year if he conscientiously considers that the relevant proceedings or investigation will last for only 6 months. There is nothing, we say, in Section 13(1) that limits the Minister's discretion to suspend only to those cases in which he considers that it is necessary to suspend the inquiry in order to allow the completion of another investigation or proceedings. Can I invite the Court to turn up Section 13? It's at EF 1146. And in terms of other relevant provisions, the Court will wish to note that Section 14, which deals with the end of an inquiry, is at EF 1147, and Section 1, which deals with the institution of an inquiry, is at EF 1141. So with Section 13 open, we say that there are 4 limitations on the Minister's power to suspend in Section 13, 2 of which are substantive and 2 of which are procedural. So, dealing with the substantive limitations first, these are the limitation of purpose in Section 13(1)(a) or (b). Secondly, the duration of the suspension is limited to the period assessed by the Minister as necessary to allow for the completion of the relevant investigation or proceedings. And detailed working out measures are provided for by Section 13, subsection 4.
How does the Minister have any control over the period of time that's necessary for the completion of the investigation?
That is a good faith judgment by him as to how long the relevant investigation or proceedings will take.
Right.
So, take for example a criminal trial. The Minister has obviously, under our Constitution, no control whatsoever over the duration
or the police investigations.
Yes,
or
yes.
Anything else.
Indeed. So he must form a judgment.
So what happens if he forms a judgment that a period of time is necessary, but it takes longer than that? What does he do then?
Well, that's what is provided for by Section 13, subsection 4.
And that is the...
So, subsection 4 provides that a notice under subsection 1, which is designed to give effect to his judgment about duration, may suspend until a specified day, until the happening of a specified event, or until the giving by the Minister of a further notice to the Chairman.
Okay, so therefore, if it takes longer, the Minister can give a notice saying, get on with the inquiry.
Yes.
Right. And in exercising that power, does the Minister take into account the public interest in the inquiry continuing?
No, that's part of the general first limb judgment. We say his judgment about the time taken to investigate, the police investigation, for example, or it needn't be a police investigation, it can be an investigation of any kind, or the civil proceedings or the criminal proceedings. So that can factor in. So if, for example, I'm sorry, trying to concentrate on this.
If the Minister is going to issue a further notice because the inquiry or the determination of criminal proceedings is taking longer than he anticipated, so he wants the inquiry to continue, obviously he's acting, taking into account the public interest in the inquiry continuing. Is that right?
Well, in fact, he can take into account. We accept this. He can take into account that exercise at the outset. So he's not bound by a test of necessity on the issue of suspension or not. He's bound by necessity, the assessment of necessity. How long will it take?
Okay, so
but if, for example, he thinks this is an open-ended trial, I have no notion of when this trial may come to an end, that he can factor that information into the exercise of his discretion on the issue of suspension or not.
And on the issue of suspension or not, when you were opening, you used the phrase desirable.
Yes.
But in your written case, you say highly desirable.
Well, yes, but he's not limited. The Minister may, in fact, decide, well, I'm not going to suspend because in my general public interest exercise, I'm not satisfied that let's use that more weaselly word, appropriate to do so.
But what is the... is it appropriate? Is it highly desirable? Is it desirable?
It's at large, governed by public law principles.
So if he just feels like it?
Well, if he feels like it, that rather suggests that would veer towards an irrational decision. It has to be a conscientious judgment, exercising ministerial power in the public interest to decide whether or not he should, in fact, for example, avoid duplication. He should take a prudent, preservative approach with respect to criminal proceedings. There are a range of factors which he may properly take into account. But a trivial, I feel like it, plainly, on the lady's example, would tend to be open to challenge on established public law principles. So we've looked at the two substantive limitations on the Minister's power. There are then two procedural limitations.
What does the word necessary mean then in relation to the period of time?
How long will this trial take? How long is needed to complete these civil proceedings?
What, in the sense of absolutely required, or just reasonable, or what?
Well, if one looks at 13.1, it is not an objective precedent fact, construction of necessity. It is the good faith assessment, such period as appears to him to be necessary.
But concentrating on the word necessary.
Yes.
Is that a requirement of a reasonable period of time, or is it a requirement of the absolute minimum that is necessary in order to achieve the objective?
It's as accurate a judgment as the Minister can make about duration.
But what's the meaning of the word necessary?
Well, how long will it need? How long is required to complete investigation X, criminal trial Y?
Not the shortest period of time that is necessary to complete the inquiry.
Well, that will typically be that. So the trial will be over in 6 weeks. Well, I won't suspend for 5. I think it'll take 6, but neither will I suspend for 10, because that would be unnecessary.
I mean, the trouble that the Minister is in is that he's not in charge of the listing of criminal trials. So he doesn't know. He may have an accurate estimate that it's going to be 6 weeks, but he doesn't know whether it'll be listed in 6 months' time or no.
Yes.
So he has to take that.
He does, and that's why, as appears to him. So there is a duty, obviously, again, in public law principles of reasonable inquiry, but it's his or her judgment as to how long the investigation or the trial will take.
If the Minister suspends for a fixed period, let's say a year, and then taking my Lord's example that actually things are taking longer, then it seems to me the Minister would have to exercise fresh his power under subsection 1 and give a further suspension notice.
Respectfully agree, unless he's made some other initial provision.
Yes. He's suspended for a year.
Yes, respectfully agree, my Lord. So we are then starting to look at the procedural limitations. So the first of these is that before making a decision to suspend, the Minister must consult the Chair. And secondly, reasons must be given and laid before Parliament or the Assembly, depending on which legislature is relevant. And no other limitation is embedded in Section 13. Obviously, as we've said in exchanges with the Court, the power must be exercised in accordance with the principles of public law, and Parliament takes that for granted in its enactments, and we have a recent powerful statement to that effect in O at EF 1224, paragraph 41. I won't ask the Court necessarily to turn that up, but I'll give the reference is clear enough. And I say that's a simple, it's a recent statement of a pretty well-established principle, so I don't imagine that will be contentious as between the parties.
What's the principle?
Yeah.
The principle is that when Parliament enacts, it is assumed to do so against the background of the common law and well-established legal principle.
So your essential submission is that as regards the decision whether to suspend, we're in the normal realm of public law principles, but in respect of the period, the minister has to satisfy himself that it's necessary.
Yes.
I suppose one might ask, why on earth would you have that distinction?
Because there is an open textured issue as to why suspend. Should I suspend? Is it a good idea to suspend? But it's purpose limited. That's a substantive limitation to see whether or not these proceedings can come to an end. And there's a requirement to ensure that the purpose-based limitation is meaningful. It's limited to the time necessary for the completion.
Why wouldn't you just apply normal public law principles to that question as well?
Well, that could have been a legislative choice, but there has been a specific insertion of a necessity assessment as respects the period of time.
But does it make sense to have that conflicting approach on the face of it within the same ultimate decision?
Well, there are always a variety of legitimate legislative techniques, but we say it makes perfect sense to have a relatively open textured assessment on the issue of suspension or not. But if the suspension is purpose-based and purpose-limited, as it is, then to make that effective, it has to be anchored in the time necessary for the relevant other investigation or set of proceedings. Now, the Court of Appeal, the respondent and the inquiry all say that Section 13 gives rise to one question which must be answered. So if one looks at what the Court of Appeal say about this, it's at EF 199. Paragraph 47. The court will see the entirety of that paragraph, but we draw attention to the last couple of sentences beginning. There is no reason why Section 13.1 should be broken down into two parts. The sentence naturally reads as one question which must be answered. To our mind, the relevant statutory provision must be considered as a whole and as requiring one single coherent decision. And in the inquiry's case, at paragraph 50, EF 139, and in the respondent's case, at EF 114, paragraph 15, they say...
Sorry, can you give those references again?
Of course. The inquiry's case, paragraph 50, EF 139, and the respondent's case, EF 114, paragraph 15. And we say this, with respect, cannot be correct, because indeed, as the learned judge at first instance observed, as quoted by the Court of Appeal, EF 187, and I'd ask the Court to turn that up. At paragraph 14, paragraph 144 of the first instance judgment is reproduced in its entirety. And if one begins with the indented quoted paragraph beginning clearly the section provides the Minister with a discretion. He may suspend. It could not be suggested that there is a presumption for a suspension, but rather the section points to both. We emphasise that, the suspension and the period for any such suspension to be necessary. And that, in many ways, is the value of having a look at Section 4, subsection 2 of the Contempt of Court Act 1981, and the court will find that at EF 1201.
Sorry, before we go to that, you said the reason why the one question point can't be right is, and then you took us to Mr. Justice Colton's judgment.
Yes, and where
I
he
didn't understand why you're saying it can't be right.
Well, because he acknowledges that there are two issues in that paragraph, and the clue is in the use of both the suspension or not, and the period of any such suspension. So there are two issues:
yes.
One, suspend or not, and two, the period of any such suspension. And textually, we say that with respect is obviously correct, and it's helpfully illuminated when one looks at Section 4, subsection 2.
Mr. Larkin, is it helpful to refer to a completely different statute? I appreciate the word necessary is used twice.
Yes. Well, that's a point powerfully made by both the inquiry and the respondent. We draw attention to it primarily because it illuminates the twofold nature of the decision-making exercise. Yes, of course, necessity is used twice. We say that's not an accident, and that assists us. We don't say that one simply reads across. As one knows, there are a variety of perfectly legitimate and more or less effective legislative techniques. But what the real value in Section 4.2 is when one is preventing something or directing something to happen, there is both the decision yes or no, and for how long. And that, we say, is the real value provided by Section 4.2. It illuminates the issue, and it tends to suggest that the approach of the Court of Appeal in simply seeing one issue, whether there are two, as incorrect. So it's not the only way, obviously, that it could have been done, but there is value in seeing that it was done this way in a case where there was also an issue of, will something happen or not? Will there be a prohibition on publication? And if there is to be a prohibition on publication, then how long will the prohibition stay in place? And again, perhaps understandably, and this is where there is a useful comparative purpose in looking closely at Section 4.2, one is here dealing with the restraint of a right, publication, and therefore it's quite proper, one might think, that that be subject to a necessity test, whereas here one is dealing with an in-the-round public interest evaluation, which naturally, one might think, ought not to be subject to such a limitation. So, if there is to be a suspension, then obviously the question of its duration inevitably arises. And we say that necessary in Section 13.1 applies only to the duration of any suspension. There are two grammatical or textual arguments which we say underpin that. Firstly, and considering the nature of the word necessary, the adjective necessary qualifies the noun period. This adjective doesn't qualify any other noun in Section 13.1, and indeed, if one were to rewrite Section 13.1, replacing the verb suspend with the noun suspension, the adjective necessary still could be stretched, simply couldn't be stretched to apply to that and to qualify that. Secondly, we invite the court, looking at Section 13, to read the words for such period as meaning nothing else but for such period as. The approach of the Court of Appeal and of the respondent and inquiry is, at least impliedly, to replace the words "for such period as" with the words "if it." And that is to replace an evaluation of time, which is what the legislature has provided for, with a general conditionality. So we said there is simply no warrant for such a textual replacement. So if we then move away from looking at Section 13 directly to Section 14, of course, the purposes for which there may be suspension in Section 13 are purpose limited, but termination of an inquiry is plainly a more significant event than suspending one. And that more significant event is professedly, and it appears to be accepted among the parties, not subject to a necessity condition. The inquiry says that a necessity test, and the reference is to paragraph 58 of the inquiry's case at EF 142, would be unnecessarily restrictive and arguably unworkable, but it is, with respect, difficult to see how this could be so, especially since the concept of necessity is invoked in the explanatory notes. Now, we will have quite a bit to say about the explanatory notes and their value in interpreting the legislation, but it is perhaps a paradox that here we see in the explanatory notes, and the reference is to EF 1481 at paragraph 22, and I'd ask the Court to turn that up. So paragraph 22, this clause sets out how an inquiry comes to an end. An inquiry is not permanent. It only exists between the setting up date and the date on which it ends under this clause. In most cases, an inquiry will end when the chairman has submitted a report to the minister and has done any further work necessary to wind up the inquiry, such as cost assessment. However, there might be situations before the submission of the report in which it is no longer necessary or possible for the inquiry to continue. So there's a reference then to essentially a necessity test or an impossibility test, neither of which, of course, feature at all in the text of Section 14. So, Section 14...
It's not a test of necessity, is it?
No.
No longer necessary.
Yes, but
rather different test.
Oh, it is, but
suggested for Section 30.
Well, it's phrased in the explanatory notes in actually absolute terms, so it would be a precedent fact necessity that it must be objectively arrived at. But of course, one sees that the point that we're making is that there's not a trace of that anywhere in the text of Section 14, and that's what matters. But there would be no particular reason why there couldn't be an assessment of necessity. Indeed, one might, if one was on policy grounds arguing for such a test, Section 14 might be the better place to put it. Section 14(3) and 4 mirror Section 13(3) and 5. The duty to consult the chair and the duty to give reasons and to lay them before the Assembly or Parliament. We say they tend to support a reading of Section 13 that sees in the Minister's purpose-limited suspension room for consideration of a range of factors wider than a mere assessment of necessity. I should say that paragraph 27 of our case has been badly proofed, and that by necessity should have been inserted in the last line on EF 102. Can I then turn...
Sorry, paragraph 27
yes,
of your case.
EF 102.
You say the last line should be amended.
There should be the insertion of by necessity at EF 102. So after the citation of sections 13(1)(a) and B.
I'm sorry, I'm missing the page numbers. Sorry.
It's EF 102, my lord.
And paragraph
27. By the insertion of by necessity after the paragraphed, the bracketed B. So, turning, I want to say something briefly about the explanatory notes. The explanatory notes, as is acknowledged, EF 1478, paragraph 1 and paragraph 2 are firstly not endorsed by Parliament.
Well, is that the test? Because in Lord Hodge said, prepared under the authority of Parliament, not endorsed by Parliament.
Well, I regard, we respectfully submit, my Lord, that those are largely synonymous, and we have assistance on this in AAA at 1344. At paragraph 140. In the process of seeking the meaning of the words which Parliament has used, external sources necessarily play a secondary role. In the present case, none of the extraneous aids relied upon gives rise to an ambiguity capable of displacing the clear and unambiguous meaning of the statute. The statements in the explanatory notes relied on do not assist ASM because they are not exhaustive. The explanatory notes state that they are not and are not intended to be a comprehensive description of the bill. Paragraph expressly is a non-exhaustive list. Similarly, the statements in the Parliamentary Committee reports and materials are not exhaustive. So we say that this has expressly at least one of the features identified that it's not exhaustive, and it hasn't been endorsed by Parliament.
When are explanatory notes endorsed by Parliament?
Well, they're not.
Yeah, well, then that can't be the test.
But they could be. But as a matter of practice at present, they're not. Yeah. They're prepared by the relevant department.
Yeah, and they're circulated under the authority of Parliament.
But they're not approved by Parliament, my Lord.
The phrase used by Lord Hodge was under the authority of Parliament.
Well, that
approved by Parliament.
In our respectful submission, that refers to some endorsement by Parliament, and of that there is
no trace. I don't think it does, and I don't think there's been any case where explanatory notes have been endorsed by Parliament.
No.
I mean, I think I'm not absolutely sure what it means being authorised by Parliament, but I think it may mean that it's circulated to members of both houses with the bill.
Yes, but it has
got any greater.
Yes. No, but that's the standard health warning for all of these, and that's why they are necessarily of very limited value.
Lord Stayne said in the National Asylum Support Service case that they're admissible aids on the objective setting and contextual scene, and on really the purpose.
Yes.
You don't dispute that?
No, we don't. But there's no assistance on the construction of Section 13.
Well, save in relation to the purpose. They may shed light on what the purpose was.
And the context, the policy springboard against which the enactment is made. But again, when one looks then...
Before we move away from that one, I'm sorry, there may be... again, going back to 1219 and Lord Hodge's statement, he said, explanatory notes prepared under the authority of Parliament may cast light on the meaning of the particular statutory provisions. And so he contrasted that with Law Commission reports, which may assist to identify the mischief and the purpose. But as far as explanatory notes were concerned, he thought that they may cast light on the meaning of the particular statutory provisions. So not only the purpose, but also the meaning.
Perhaps that can't be ruled out, my Lord, but it's instructive that in neither of those two recent cases, O or AAA,
Yes.
Do they in fact shed light on the relevant provisions that were an issue in those appeals?
Well, there was a lot of concern at the time that the Minister was being given too much power to interfere with a public inquiry, and Parliament was being reassured that this was only be the power would only be exercised in cases of necessity.
Well, in fact, when one looks at the specific provisions that deal with Clause 12,
Yes.
as it then was, one finds that they're not, in fact, helpful or illuminating. No more, in fact, than was the provision to which I've already taken the court in relation to what was then Clause 13, now Section 14, which suggests that there is a necessity test when quite clearly on any reading of Section 14 there is not. So if I could then ask the court to look at paragraph 20 of the explanatory notes, which are at 1481.
Yes.
Paragraph 20 says an inquiry may be one of a number of investigations into a particular matter. Often the respective timing of these is very important. For example, to ensure that an inquiry does not prejudice a criminal prosecution. The results of other investigations may also inform the inquiry and help prevent duplication. So if one considers those words, the results of other investigations may also inform the inquiry and prevent duplications. That is, if one may say so, an entirely sensible observation. But one wouldn't normally speak of the necessity of avoiding duplication or of relying on other investigations. And this, we say, is classically the territory of desirability or policy choice or indeed financial prudence. And if one looks at paragraph 21, this is posited on new investigations or proceedings that come to light or are commenced after the inquiry has been established. And if one looks at section 13, again at EF 1146, at subsection 2, the power conferred by subsection 1 may be exercised whether or not the investigation or proceedings have begun. So there is one would read what's in the explanatory notes as suggesting that this relates only to new things or things that come to light after the inquiry has commenced, and that cannot be reconciled with the clear words of subsection 2. And if one looks again at paragraph 21, one sees at EF 1481
Sorry, can you just give that reference?
Yes, it's EF 1481, and it is the paragraph 21. If one looks then at the second sentence in paragraph 21, this clause sets out the circumstances in which a minister may suspend an inquiry to allow other proceedings to be completed. Well, indeed, that's exactly what it does, but there's no reference there to necessity.
But it does say in the previous sentence it may be necessary to halt the inquiry temporarily.
Yeah, but that is again based on in the event that new investigations or proceedings come to light or are commenced after the inquiry has started, and we know that can't be reconciled with the text of section 13, subsection 2, which says that the power can be exercised at any time.
So you're sort of saying that paragraph 20 of the explanatory notes is directed to existing inquiries and proceedings, and paragraph 21 is directed at new investigation.
Whereas subsection 2 isn't at all limited in that way. So there's really, we say, no assistance to be derived from this, and certainly no assistance that gets over the difficulty that the adjective necessity qualifies the noun period. Nothing else.
Mr. Larkin, I've got one eye on the clock because we're operating under very strict time constraints this morning, and you've got about 5 minutes.
Yes, well, thank you, my Lord. So can I make the court has our point in relation to section 14. It refers to, the notes refer to essentially a necessity test, and that's entirely at odds with the open textured nature of section 14. Two quick comments on the respondent's case. If one looks at EF 114, paragraph 19 of the respondent's case, the second limb referred to there is not our second limb, which is an assessment of how long will these proceedings take. It is simply a rerun of the respondent's proposed test after our test. A proper example might well be to posit a minister who, hearing of a criminal trial overlapping with an inquiry for which she is responsible, decides that it would be, subject to consulting the chair, prudent to suspend the inquiry and asks officials to give her information on the likely duration of the trial. On the following morning, the minister is told that the defendant was acquitted yesterday. On such a scenario, there is no trial to complete, and therefore there would not be suspension. If the minister is told, on the other hand, that case is a complex fraud, it's going to take 7 years, Minister, the minister will decide, well, I'm not going to put the inquiry into cold storage for that length of time. That's the proper basis on which the issue should be approached. There is a rewriting exercise in the respondent's case at EF 115, and we say what is significant and helpful. It's EF 115, paragraph 20.
Yes.
What is significant and helpful about this rewriting exercise is that it draws attention to the fact that it's only the deleted words that require an assessment of necessity, but it is an assessment of the necessary period of time. Paragraph E of the inquiry's case presents, we say, an argument in favour of the existence of a general power or general necessity test. That's a perfectly understandable policy argument for the inquiry to make, but it's not an argument rooted in the text of section 13. The short answer to the inquiry's argument ab inconveniente is that the minister is obliged to consult the chair before suspending the inquiry and must give reasons for suspending the inquiry. A good faith consultation exercise, and this is what Parliament has presumed to occur, will result in the conscientious taking into account of the product of the consultation, and that will be normally evidenced in the reasons given. Finally, on Pepper and Hart, we said 3 tests have to be satisfied. The first isn't satisfied, and the third certainly isn't. The Hansard material is very far from clear. We've cited a very old case of Vasher, EF 1398, and there's a really important statement of principle which doesn't appear to have been considered in Pepper and Hart. By the way, we're not asking, of course, this court to overrule Pepper and Hart, but it does emphasise the caution that has historically been exercised with respect to Pepper and Hart ever since, and we say that there is nothing there which should cause the court to stray away from what we say is the clear text of section 13.1 and its limitation of necessity to the period of time. So, Lady, my Lords, unless there's anything else, those are our submissions.
Thank you, Mr. Larkin. Mr. Cole.
Thank you, Lord. So, Lords, initially this judicial review challenge was couched in what might be described as substantive terms, hard-edged challenges to the continuation of the inquiry, particularly in terms of the impact that the continuation of the inquiry would have on the appellant's criminal trial process. What has developed now at the point in time where we've, within the High Court and then at the Court of Appeal and now obviously in this court, is a question going to the parameters over the breadth of the ministerial discretion to suspend the inquiry. That's encapsulated in the further amendment to the Order 53 statement that we see at paragraph 5.1, Romans 6. In the judgment of the court at first instance, Mr. Justice Colton addresses the steps and the efforts that have been taken on the part of the Department and the Minister in considering the interplay between the work of the inquiry and the criminal investigatory or prosecution processes in advance of the establishment of the inquiry, and see that in particular at paragraphs 53 to 78 of the judge's judgment. And he then went on to summarise the steps that have been taken by the inquiry vis-à-vis the impact on criminal proceedings through to paragraph 105. And at 106, he sets out in summary the work of the inquiry and the impact that suspension would have. I don't ask the court to turn that up, but you find that at EF242. And the reason I have opened my submissions this morning by relating back into that kind of territory, albeit briefly, very briefly, is that it gives the court, when it has an opportunity to consider it, an opportunity to look at this in the real world setting, in a context that allows it to come to life. Because plainly, any step taken by a minister having established an inquiry to suspend the work of the inquiry can, depending on the circumstances, have very weighty impact on those either involved in the work of the inquiry or who potentially may benefit from the work of the inquiry in due course, and that includes obviously the public interest. So the contextual backdrop to all of this, not just in hypothetical terms, but actually in the cold reality of what is actually happening in the Muckmore Abbey Hospital inquiry, is important because it sets the tone for what Parliament was doing when legislating in this field in 2004, 2005, and in bringing into existence what we now see at Section 13. So if I could ask the Court then just to turn again to Section 13, which obviously you're very well familiar with, but in particular turning to obviously Section 13 at page 1146. And
couldn't the Minister take into account all those public interests, even if it was an open-ended public law discretion as to whether or not to suspend?
Yes, Lord, I think that's right, and indeed would probably be a requirement in terms of administrative law or public law. But I think that the difference here, the distinction is that Parliament was setting the ministerial room for manoeuvre in a much tighter way because of the heightened impact that can arise from suspension of the work of a public inquiry. Obviously, the setting up of a public inquiry is not a step that's taken lightly. To suspend it during the course of its work can give rise not just to practical difficulties, delay, issues about witnesses giving evidence, etc., the learnings that might come from the inquiry in due course, but there's also an important aspect of the public confidence, the public being assured that in taking this step, essentially, it is a necessary step, that it's not something that is more easily open to perhaps ministerial abuse or convenience or anything of that nature.
So there was a concern that ministers might not like the way that the direction the inquiry is going or the findings that were being made, and might suspend on that basis.
Yes, my lady, and indeed you can see in Mr. Beer's work those kinds of issues being referred to. I've mentioned this gingerly because I want to go into the issue about what happened in Parliament and the debates about this unnecessarily before this court. But you can see that Mr. Beer in his work does give life to the fact that the parliamentarians, in bringing this legislation into life, were alive to these kinds of issues. And I couch it in terms of the public confidence, the importance that the work of an inquiry is not seen to be undermined by the government, who of course may have set it up, but may not necessarily welcome the workings of any particular inquiry. One can put it in that rather oblique kind of way. So when one looks to Section 13 at 1146, And just to read the first part of it.
I suppose if that was their concern, they would terminate the inquiry.
Well, terminating, as I'm going to come to this point, termination of an inquiry before its work is completed can be an intensely political act.
Of course, well, so would suspension be.
Well, the suspension of it, it may be that the suspension of it could be couched in different terms, and one's mindful of the fact that irrespective of which interpretation of Section 13 this Court takes today, in respect of this, there is already, undoubtedly and without any controversy between the parties, a restriction on the opportunity of the Minister to suspend an inquiry. It must attach itself to what the Court of Appeal described as one of the gateways that we see in 13A and 13B. So Parliament is already...
So that does rather limit the ability to use the power of suspension for nefarious purposes.
It does, my Lord, yes. It's part of a continuum in that regard, we say. And it can't be used as a badge of convenience or a flag of convenience. So if the Court will indulge me just to allow me to read 13.1, I'm conscious the Court's very well aware of what it says, but I think it does bear hearing it read and allow me to then make some submissions in respect to it. So the Minister may at any time, by notice to the Chairman, suspend an inquiry for such period as appears to him to be necessary to allow for A, the completion of any other investigation relating to any of the matters to which the inquiry relates, or B, the determination of any civil or criminal proceedings, including proceedings before a disciplinary tribunal arising out of any of those matters. So in that short provision, we see the encapsulation, we say, of the one test. It is a unitary test with two limbs to it, but it is the one test. It's framed as one decision. It's contained within the one part of a single sentence, within the one subsection, within the section, within the Act. Everything about it lends itself towards consideration, as the courts below have found, and as the point of view the Minister had taken in respect of it, as being the one decision with necessity applying to it in its entirety. We say it is telling that that's the approach that's been taken to the formulation of the provision, and it has not been broken into two different elements. And likewise, it's also telling that it does not say something to the effect of that the period of suspension shall be for no longer such period as necessary for the matters at 1A, 1B, which would have been an opportunity or a means by which Parliament could have framed the legislation if it was meaning the word necessary only to attach to the posterior aspect relating to the time of the suspension.
But that on any footing, surely that is part of subsection 1. I mean, you're not arguing, are you, that that on the one hand the Minister can only suspend if it's necessary to do so, as part of your argument, but when he chooses the period, he can choose a period longer than is necessary. No. So, I mean, on either reading, yep, it is a limitation on the Minister's power because it's for no longer than is necessary, yep, for one of the purposes.
Effectively, my Lord, we say that the necessary concept of necessity applies to both aspects.
I appreciate you say it applies to both, but on any footing it applies to the period.
Well, yes, indeed. Yeah. Yes. And the Court of Appeal, we respectfully say correctly identified that, I think it's paragraph 47 of its judgment. My Lords and Lady, I have been then going to take you through some of the documentary aspects of this. My Lord friend, Mr. Larkin, in some measure, large measure, done that already. Perhaps the Court will allow me just to give some EF reference numbers for assistance to the Court in due course of the applicant's, the departmental submission to the Minister made on the 27th of June 2022 is found at EF 1004. The Minister's decision at 316. The official involved, Miss Montgomery, her affidavit evidence deals with this not in the context of describing what necessity might mean, but just the process that was followed, because the issue about this particular issue didn't arise in the case at the time in which her affidavit was being filed. But you can see her affidavit in respect to this at 646. The applicant's second letter of the 7th of July 2022 is at 1017. The Minister's reply at 1020. And the very short sub to the Minister relating to that of the 4th of August is at 1061. Essentially, in this case, the applicant's argument is that the Minister and the courts below have fallen into error in holding that the suspension itself must be necessary, and fell further into error in failing to hold that the concept of necessity was only applicable to the period of suspension. Your Lordships, lady, have our point that we say, in fact, that's the wrong approach to take to this. One should not disaggregate the statutory wording. It should be looked at on the whole.
Can I just ask you this? I mean,
yes,
looking at it purely as a textual matter, without any other considerations, is it your case that we should effectively delete the words on one version for such period, so that you say it can be read perfectly naturally? The Minister may at any time, by notice of the Chairman, suspend an inquiry as appears to him to be necessary to allow for. Is that a reading that you think is permissible? And then we put back in the words for such period, and you read the qualification as applying to both?
That could be one way of doing it, my Lord. I think the point we make is that the language that has been used lends itself to being read as a whole. So the concept of necessity applies to both the aspect of suspension and the period of time of suspension.
I understand that, but to get to that it can be read as a whole, you have to, I think, accept that as appears to him to be necessary can be viewed as qualifying, suspend an inquiry.
Yes, that would have that effect, Lord, yes, that's right. But then one has to somehow bring it back into play in terms then of applying necessity to the period of time as well.
Oh, yeah, but I think the point being put against you was, as appears to him to be necessary, is simply qualifying the period. As I understand it, you're saying, even as a matter of text, that's not the case necessarily, no pun intended, but that the words as appears to him to be necessary qualify both suspend an inquiry and for such period.
Yes, Lord, that's right. So we, as your Lordship and Ladyship will have seen from our written case, we consider respectfully that the appellant's approach this is a laboured approach, to an artificial approach, lends itself to legalism, and that it is, again, to use a word perhaps advisedly, it's not necessary to look at it in this way. But once an inquiry is established, the ministerial power to suspend is not open-ended. We talked earlier about it being specifically curtailed in factual scope by Parliament by way of A and B, that one of those two gateways, as the Court of Appeal phrased it, must be established in order for the suspension to be engaged at all. In that sense, one can say that the consideration of suspension doesn't simply operate within the normal parameters of public or administrative law. There is an extra element brought to it. And if the appellant's argument were to be correct, as we had set out at paragraph 20 of our written case, which is found at EF 115, in essence, it would allow for a reading, a much simpler approach could have been adopted. A reading would have effectively been as set out there in that part of our written case, that the Minister may, at any time by notice to the Chairman, suspend an inquiry until and then A or B would come into play. And effectively we contend that if Parliament were simply saying that the setting of the period is the only aspect that requires the concept of necessity to be applied to it, that in that sense the ordinary confines of rationality could properly address that. It would be unnecessary, again using that phraseology advisedly, for Parliament to take the step of suggesting that there must be a further curtailment of the power to suspend only relating to the period of time. And what we mean by that really is that if in fact the power to suspend per se was open-ended, the Minister took that course, but he then decided that he wanted to apply a period of time of suspension of, say, 5 years, that was completely divorced from the reality of the underlying investigation or proceedings, etc., that the rationality of that would be a matter that would be amenable to judicial review challenge. It would not be necessary to add in a further layer of necessity by itself. Really, what the introduction of the concept of necessity into the scheme is reflective of a parliamentary intention to make it, put bluntly, as difficult as possible for a minister to intervene in the workings of an inquiry and to suspend it. In other words, that hard-edged decision, the fundamental decision about suspension itself, is something that is more likely going to attract the requirement of necessity than simply the timing of it thereafterwards, because the timing of it thereafterwards would be attached to gateways A and B and would have to rationally connect to what's happening in relation to that gateway A or B. It's for that reason primarily that we say that the natural reading of Section 13 is that which the Minister has adopted, which the High Court has adopted, the Court of Appeal has adopted, and which we proffer to the Court today. On the appellant's approach, the Minister...
Can I just
yes,
be sure I've understood that point? So you're saying that it would seem a bit odd if you're going to use the term necessity to confine it to what you might regard as the more subsidiary issue. The major question is whether to suspend, and the logic of keeping that to necessary, well, one can understand the logic of that, because this is a pretty drastic step to stop an inquiry that you've set up. Whereas to have necessary simply applying to the period would, in comparison, that's relatively trivial.
It seems rather lopsided, Lord, if I could put it that way, to apply it simply to the ancillary or subsidiary aspect and not to the fundamental aspect. When you're dealing with a heavy-hitting, hard-edged concept such as necessity. In other words, if a minister were to make a decision to suspend an inquiry, if our argument is correct and there's a challenge to that, one envisages a situation whereby counsel standing on behalf of the minister in the Judicial Review Court having to actually justify it on the grounds of necessity, that there is a bite to that, it means something, it's a parliamentary intervention into the ministerial discretion, flexibility, that actually makes a difference. Whereas confining it simply to the timing of it, while not devoid of impact, is of a much lesser impact and seems to be out of kilter with the steps being taken in an uncontroversial way in relation to the limiting of the factual circumstances in which the suspension can be applied in the first place.
So your argument is that although it may be in the public interest to suspend the inquiry, it cannot be done unless it's necessary to do so.
Yes, Lord, that's right. And the assessment of necessity, of course, might be influenced by what is in the assessment of necessity might be influenced by what's assessed to be in the public interest.
But highly desirable in the public interest isn't enough.
No, my Lord, and just while your Lordship raises that point, is an issue I was going to come to in due course, and I'll maybe just deal with it briefly now. The question that's been posed by the courts below in respect to this, in a sense, is if the test for suspension doesn't impute necessity, then what is the test? And my own friends, with the greatest respect to them, don't really answer that. There are suggestions of different wordings, different concepts that can be put to it. Indeed, as my lady has identified this morning, even within those concepts, they are pliable and can be open to interpretation and perhaps some further adjectives to be applied to them, very, highly, etc. And the uncertainty that gives rise to, again, calls into question, why would Parliament take this course? If it was actually intending to corral ministerial flexibility, then should it not do so? Should it not do so in a way that can be understood? The Minister knows where he is, he knows what he's allowed to do and not do. These concepts of... Sorry.
The simple answer is that the test is a public law test. That is, there's a discretion, open-ended, is given to a minister to suspend, and he has to exercise that discretion in accordance with the Wednesbury principle.
Yes.
Takes into account all relevant factors, leaves out of account irrelevant factors. And you don't have to define what the test is. All you have to define is that the minister is not permitted to make a Wednesbury unreasonable decision.
Indeed, it really leaves it in the territory, my Lord, of rationality when it boils down to it. My own friends use the phrase highly desirable, appropriate, etc. None of those actually have any meaning. They don't bite in any way. They're words that are lifted off the street. What we'd be talking about would simply be a classical rationality challenge, that the Minister's decision to suspend was irrational. And depending on the outcome of this appeal, if the court goes against us, then that's effectively where the matter will be left. But it does seem rather incongruous in that context. It would be a rationality challenge on one level, and then the period of time over which that rational decision could apply would be subject to a necessity test.
Well, there might be an Article 2.
There could be more, indeed, yes, that's right. And one thinks, for example, in the Northern Ireland setting of potential public inquiries or actual public inquiries where there may be more hard-edged Article 2 type provisions under the Convention, indeed, yes. But in the ordinary course of events, one's more likely to find it being restricted to a rationality challenge in classical terms. Just want to check my time. I think I've got some time left. So in summation on that point, effectively our submission to the court is the affixing of necessity to the ancillary posterior question seems like a rather unnecessary step on the part of Parliament. We respectfully suggest that in a purposeful type way, looking at the language, it seems more than tolerably clear that what Parliament was actually intending was that the decision as to whether to suspend or not would be curtailed by the concept of necessity. My learned friends draw some comparison with the commencement of an inquiry or the ending, and perhaps more focus put on ending of the inquiry, and they make the argument that it seems somewhat remarkable that Parliament would require necessity for suspension but not apply a similar test in relation to termination of an inquest prior to its normal completion. The court will be aware from our written case that our response to that is a brief one. That's effectively to say they are contextually different decisions. That it's not actually terribly straightforward to apply the word necessary into the making of what would effectively be a negative act of terminating an inquiry. It's different in nature from the positive act of suspending something that otherwise continues to exist.
Well, you could write it in, couldn't you?
I'm sorry,
You could write it in. If the Minister considers it necessary to do so, he may terminate the inquiry.
yes, well, it's possible, but
Why?
sorry.
Yes, go on.
No, I'm sorry, I don't mean to cut you.
No, I mean, you made a strong point, I thought, in relation to suspension about public confidence.
Yes.
But does that not also apply in the case of termination?
Well, the termination of an inquiry is, and I used the phrase earlier, very often would be an intensely political act in a way that's somewhat different from the limited circumstances in which suspension can be applied. So Parliament has not taken the step, obviously it wouldn't be feasible to do so, of trying to limit or list the circumstances in which...
But why would it not be feasible to do so?
Well, if one takes a comparison with what's said at 13A and B, so the gateways are there is some other inquiry underway, or there are proceedings. Obviously, that kind of situation can't apply at a termination stage. Because what's happening in Section 13 is a pausing of the work of the inquiry to allow something else to take place. The Section 14 exercise is a terminal exercise. It's a fundamental ending. The range of circumstances in which that might be the appropriate course to take on the part of the Minister are not listed by Parliament, and realistically it wouldn't be possible to list them. There could be any range of matters within the vicissitudes of human existence. And so in, for example, the explanatory notes, which I won't take you to at the moment, my learned friend Mr Larkin drew from that in relation to the power to terminate. What's happening in the explanatory notes is provision of examples. That's all. Parliament can't set out, well, it could have. I suppose one might say it would have been open to Parliament to say only in certain circumstances will a Minister be able to intervene in an inquiry and bring it to an end. The risk, of course, in doing that is that you wouldn't be able to envisage what each of the circumstances might be in the particular dynamic of any actual inquiry in due course. So, for example, you could have situations where the politics of the situation has changed. You could have a scenario whereby one political party has, in its manifesto in a general election, that it will end the inquiry into X, may get an overwhelming support of the people in that regard and feel that it has a political mandate to do that. It may not be, in that conceptual sense, necessary to do it, but it may be something that is recognising the will of the people, a democratic exercise to bring it to an end. One could envisage circumstances whereby an inquiry had gone on for many more years than might have been envisaged at great public expense, and the public effectively weren't prepared to pay for it anymore, and that the government intervened to bring it to an end. There's any number of circumstances, including that it may simply not be a matter of utility anymore. The world may have moved on, something might have happened, and it may not be any longer to serve any useful purpose to continue it. None of these would meet the concept necessarily of necessary. The distinction to be drawn at the suspension consideration is that on our case, the necessity must be tied in to the gateway factual reason. That is the key distinction between suspension and termination. I don't propose to say very much about the suggestion that Mr. Beer's learned text should not be a matter of consideration by the courts in deciding what the appropriate interpretation of Section 13 might be. We've set out in brief what we say about that in our written case, and I propose to leave that unless there are any particular questions in respect to it. Not resigning from it.
It may be that Mr. Beer is not addressing the specific matter which has been raised in these proceedings.
Well, I think, Lord, it probably is fair to say that it wasn't been looked at through the specific cutting lens of these proceedings, obviously. And that's no harm to any of the learned authors and editors of that work. But still it is of interest. We say...
Well, to be persuasive, it's got to be reasoned and cogently reasoned, and there is no reasoning whatsoever.
Well, there's. I think what I would say about it, Lord, is this: if the learned authors, editors of that work, many of whom are known to us all, if they had formed the view that in fact Section 13 said something contrary to what they briefly put it forward to be, then we would imagine it would have been tested out by them and they would have drawn that to the attention, because it would be a rather important point for any student of public inquiries to be able to ascertain. So we say that there is something to be taken from the fact that they have looked at it in the way they have, and that it is, in more than a general sense, supportive of the approach that's been adopted by the two courts below and by the Minister and indeed by the inquiry. But I put it perhaps no stronger than that. What I do want to spend perhaps the last 10 or so minutes of my time, maybe I've got slightly longer than that, is looking to the issue about the what can be taken from the explanatory notes. Now, I think paraphrasing my learned friend, as things have developed this morning, I think what perhaps can be taken from it, obviously you have the right to reply to me if I'm wrong in this, is that he accepts that the explanatory notes can be taken into account, can be considered by the courts in aid of interpretation of Section 13, but that in actual fact they don't make any difference to the heels of the hunt. We, as it will not come as a surprise to the court to see, we certainly do contend that the explanatory notes are a matter that can be taken into account, and indeed respectfully we say should be taken into account.
How do they help?
Well, if one looks to what's said, really, in particular go to the explanatory notes that accompany the bill, to all intents and purposes they're really the same whenever they then gets transmuted into the explanatory notes to the Act when enacted. So that's at EF 1481.
Yes.
And obviously at the time the bill was under consideration, the relevant provision was found in Clause 12, which is Section 13. Power to suspend the inquiry, so paragraph 20 and 21 of the explanatory notes. The inquiry may be one of a number of investigations into a particular matter. Often the respective timing of these is very important. For example, to ensure that an inquiry does not prejudice a criminal prosecution. The results of other investigations may also inform the inquiry and help prevent duplication. One can take from paragraph 20 interesting introduction of the word "to ensure." So that we say imbues something akin to necessity. It is a necessity and to ensure an inquiry does not prejudice a criminal prosecution. But it is, I think, really right to say that what's been set out in the explanatory notes, particularly at paragraph 20, is simply an example. I mean, it says categorically, for example, to ensure that an inquiry does not prejudice a criminal prosecution. The results of other investigations may also inform the inquiry and help prevent duplication.
Well, that doesn't suggest necessity, does it?
Not by itself, Lord, no. But again, these are matters that go to exemplify and how a picture might be built towards the establishment of necessity. So these are matters that will always have to then be considered in specific factual context. And this comes back to the very first point that I made at the start of these submissions. And then in paragraph 21, the note continues, in the event that new investigations or proceedings come to light or are commenced after the inquiry has started, it may be necessary to halt the inquiry temporarily. This clause sets out the circumstances in which a minister may suspend an inquiry to allow other proceedings to be completed. So, well, again, this is put in the context of the hypothetical, not perhaps surprisingly, given that it's dealing explanatory notes to an act which is going to have to cover a wide gamut of.
But it relates only to new investigations or things that happen once the inquiry started.
Well, again, one has to emphasise that these are the explanatory notes, so I'm not trying to undermine my
argument. To the extent that you're
argument.
getting any help from them,
Yeah.
this does seem to distinguish between investigations and proceedings that come to light after the inquiry has started and those that might have been in play before.
Well, with respect to I'm not sure that that's necessarily, again, that word again, I have to try to stop using that word, necessarily the case.
Well, why?
Because what is actually being considered here is what might be the normal, one might say, course of events. So the minister decides to set an inquiry up. Something then happens afterwards which changes the picture and brings into play whether Section 13 should be activated to bring about a suspension. This is a slightly different situation in this case, in that when the inquiry was established, it was already known that there were...
They could have asked immediately, as soon as the inquiry was established. The appellant could have asked immediately for suspension, not on the basis of any new investigations at all or proceedings. He could have say suspend, asked for a suspension, and it wouldn't have fallen within paragraph 21.
Well, I think when one looks at 21, in the event that new investigations or proceedings come to light or are commenced, I think one perhaps has to take, as we're not at this point interpreting a statute, we're looking to what's said in explanatory notes,
That's
painting a picture.
I mean, that's precisely the trouble of these names. I mean, a rather muddled picture emerges from paragraphs 20 and 21.
It's,
And also from 22, because they got that completely wrong.
And 22 as well, yes.
Well, I think, my Lord, the reason we place reliance on these explanatory notes is because they do envisage the concept of necessity applying to the fundamental decision to suspend
And to
rather
terminate.
than
And to
yes,
terminate.
yes.
And do you agree there's
That's
no
22.
necessity test in clause 14, in section 14?
Well, yes, Marie, but of course, I think I'm able to say here we're not actually having to deal with section
But we are.
14.
We have to see whether these explanatory notes help us in relation to your argument. And
Yes,
given
and-
that the word necessity appears in 21 and in 22, I'm struggling to see how they do help. That's really my only point.
Well, because the fact that they are referred to in this clause 12, that it goes to indicate that it would be in circumstances of necessity that the decision to suspend would operate.
Well, then
It creates
isn't the same true of 22? And we know there isn't a necessity test in section 14.
What it does say is, however, there might be situations before the submission of the report in which it is no longer necessary or possible for the inquiry to continue. So it doesn't limit itself to necessity in that specific context. Essentially our point is that to use the word necessity in the paragraphs 20 and 21 in that subclause, that is an indicator of what was understood by, certainly by the Government Department, the Department of Constitutional Affairs, in promoting the bill, that was the territory in which that the decision to suspend would operate. So I wanted then just to take the court very briefly to some of the points made in the authorities about the use of the explanatory notes. Now, it may be in terms of how the discourse is developed today that I don't need to go through that in line by line detail as I've been anticipating doing, so I won't do that, but perhaps some references. So in the O case, which my learned friend Mr. Larkin's already referred you to, and he's referred you to the judgment of Lord Hodge at, I think, was it, what I'm going to bring you to is at page 1228, which is Lady Arden's judgment. Hopefully.
The other members of the court agreed with Lord Hodge, didn't they?
Yes, Lady Arden, effectively it's concurring judgment by Lady Arden.
Yes, but what
she
I mean
made some
is,
further comments.
I'm just flagging the point that Lord Hodge's judgment is the one which, with which specifically 3 other members of the court.
Yes, Lord, indeed, yes. But respectfully, my Lord, I don't think it necessarily has to be taken from it that there is a fundamental disagreement between Lord Hodge and Lady Arden on this point. Perhaps just some further elaboration of it by Lady Arden, and in particular running from paragraph 60 through to paragraph 76, conclusion of her judgment. Just to highlight perhaps a couple of points from that, paragraph 63 on page EF 1229. Lady Arden said, I agree with Lord Hodge, DPSC, that such material is relevant to assist the court to ascertain the meaning of the statute, whether or not there is ambiguity or uncertainty, and indeed may reveal ambiguity or uncertainty. And then turns to paragraph 76 at 1232, in which Lady Arden held, in my judgment, it is realistic also to recognise that pre-legislative material where available may inform the court about an ambiguity which was not apparent simply on the face of the words, the mischief to which the legislation was directed, and the purpose of the provision, and may, in an appropriate case, influence the meaning of the statutory provision.
What's the purpose of Section 13?
Well, the purpose of Section 13, Lord, is, we respectfully say, to set a tight ring around the ministerial discretion to suspend the inquiry, and on the basis of what we have outlined, not just to tie it to specific types of factual circumstances, but also to require the Minister to be satisfied that it is necessary to suspend.
And what's the purpose of the legislation as a whole?
Well, the purpose of the legislation as a whole is multifaceted. The Inquiries Act is obviously designed to set out the circumstances in which an inquiry might be established, and also the conduct of the inquiry, how it's to be organised, funded, etc. And also what the powers of an inquiry might be, and then also how the Minister, for our purposes the key bit is how the Minister or the Government interacts with the inquiry once it is operational. And we respectfully say that it is the purpose of the aspect of the Act that we are particularly concerned with here is to provide a different setting to that relationship than might otherwise purely exist under ordinary public law tenets. And it is, in fact, to restrict the manoeuvrability of the Minister to act in such a fashion as to suspend and to restrict his powers to suspend to particular factual circumstances, and also to apply the concept of necessity to his decision making in that regard. The Lords and Lady, we have set out in a little bit of detail in our written case the Hansard material, and obviously that's found in the papers. We respectfully say that if the court takes the view that there is ambiguity in respect of the proper interpretation, meaning of Section 13.1, that under Pepper and Hart it is appropriate for the court to look to the Hansard materials which we have identified. We respectfully say that it is clear that the one comment that appears to have been made touching on the issue of necessity, as set out at paragraph 51 of our...
Is Lord Evans the promoter of the bill?
Well, there is, Miller friends take some degree of issue in respect to that.
Yeah.
What respectfully, we have tried to couch this in as careful a term as possible. It would appear that in the debate in the House of Lords on that occasion, if I could use this phrase, for I don't think this phrase finds recognition in any of the authorities, the main promoter of the bill was Baroness Ashton. But it does seem clear, we say, from the context of materials that we have highlighted, that she on occasion makes reference to another member of the House of Lords going to deal with some of the amendments that have been proposed, non-government amendments. And it is clear then that Lord Evans of Temple Guyton then deals with these amendments, including the amendments in this territory. We've set out in the footnote to paragraph 51 that the late Lord Evans was noted on the UK Parliament website as having held a government post, Lord in Waiting, HM Household.
It meant he was a government whip.
Yes, I think that's right, Lord. And that was from the 13th of June 2003 to the 27th of June 2007. So it encapsulates this period of time. And it seems clear from the materials when one looks at them that he's saying to other noble lords that he's going to take account, not in this particular provision, but he's going to take account of some of their suggested amendments, and that they were going to go away and think about them.
He must have been speaking to the government. Which was the sponsoring department?
It was the Department of Constitutional Affairs, Lord.
According to Wikipedia, he was a spokesman for that department in this period.
Lord, I'm glad to hear you say that, because I have actually seen that, but I was very reticent to
fair enough. It's probably for us, not you.
You were very careful not to give evidence.
I'm pleased that your Lordship has gone there. I didn't want to be the one to rely upon Wikipedia.
There you are. Lord Richards has given evidence about it.
So
for these purposes, he's the promoter.
Yes, Lord, my lady. That's what we say. And in fact, we say that if one looks through it, I won't take the court through it all, but one looks in the context of the discourse and the discussions within the debate, it contextually is very clear that that's the case in any event. So we set out again in paragraph 51 of the written case as to what he says in this regard, and it is as follows. There is some concern about the possibility that the powers in Clause 12 to suspend an inquiry could be abused. As my noble friend has explained, Clause 12 allows a minister to suspend an inquiry only when it is necessary to allow for the completion of other related investigation and determination of any civil or criminal proceedings. So, respectfully, we say that if there is ambiguity or doubt, that is very powerful clarification in respect of it. Finally, I come back to perhaps the key underlying question in all of this, which we have touched upon during the course of the discussions this morning. If the test for suspension doesn't include the concept of necessity, then what should it be? There's nothing else within the text of the Act that assists in respect of that. My learned friends draw in words from the street in an attempt to perhaps condition how one might look at that. But in the final analysis, we respectfully say one would simply be left with the confines of rationality as a starting position. I take Lord Stevens' point entirely. There may be occasions when there would be a more hard-edged requirement under Article 2 or Article 3 of the Convention that might influence the decision, but in the absence of that, one was really left with rationality. So in other words, what this Court has been faced with on the part of the appellant's argument is that Parliament effectively allows an open-ended purpose for suspension.
Limited by reference to paragraphs A and B.
Once one's through the gateways.
Yes, yes.
And that the risk could be then that it becomes opportune for any minister in such circumstances to latch on to those gateways in circumstances where, in fact, if necessity was the test, it would not be possible to establish it. So it turns the focus of the legislation simply onto the time of the suspension rather than the real need for the suspension. And respectfully we say that that would really hardly be worth the parliamentary intervention to take such a course. Well, Lords, my lady, unless there's any further, those are my...
Thank you, Mr. Cole.
Thank you.
Mr. Doran.
My lady, my lords, I act as senior counsel to the inquiry.
Yes.
And during these proceedings with one of my inquiry counsel team, Ms. Kylie Casey. My lord, the inquiry is very grateful for the opportunity of addressing the court on this point of statutory interpretation. Our written case appears at page 129. The court's determination of the point may potentially impact not only on this inquiry but also on others, and there are often other inquiries that are conducted in parallel with separate investigations or proceedings, and most typically, as in this case, the other proceedings are of a criminal nature. I think it's fair to say that it's common case that great care is required to ensure that the work of the inquiry doesn't impact adversely on those other proceedings, and in particular the criminal process. That's certainly one of the most significant challenges that has been faced throughout the present inquiry. The inquiry finds itself in a slightly unusual position in the present appeal because fundamentally the appeal concerns a provision that defines the scope of ministerial power. While the exercise of the power of suspension can only be effected following consultation with the inquiry chair, it is for the minister and for the minister alone ultimately to determine whether the inquiry should in fact be suspended. But obviously, as the court's aware, the inquiry is more than just an interested spectator in these proceedings, because the limited point of statutory interpretation that is now before the court arises from a fairly wide-ranging challenge to the very capacity of the inquiry to exist alongside the criminal proceedings. And the ultimate objective, of course, of that challenge was to achieve suspension. The inquiry emerged unscathed from that challenge, but has retained a strong interest in the point of statutory interpretation that remains at issue. I hope it is of assistance for the court to have the inquiry's input on this point, because otherwise there is something of a risk that the exercise of the statutory power will be considered in a vacuum. Now, I propose to make my submissions in 4 stages for the court's assistance. First, I want to make a brief reference to how the landscape of the inquiry itself has changed since October 2022, when this matter was last before the Court of Appeal. And in so doing, I'll elaborate on some of the detail provided in sections B and C of the written case. Secondly, then, I want to say something about why the context is important for the purpose of the court's consideration of the scope of the Section 13 power. And in this part of the submission, I build on some of the argument in Section E of the written case. Thirdly, I then want to return briefly to the language of the statute, and I appreciate that that territory has been covered extensively by my learned friends, but I do want to say something by way of support for the interpretation adopted by the Court of Appeal. And this is addressed in some detail again in Section D of the written case. And fourthly, and very briefly, I want to say something about the analogy that the appellant has sought to draw between Section 13 and Sections 1 and 14. The court obviously has already heard some argument about that. I then conclude with a general observation about the importance of providing an inquiry with relative freedom to conduct its business with certainty and, if I can put it like this, removed from the shadow of potential suspension. First, looking at how the inquiry has moved on from the time at which the Court of Appeal handed down its decision in the case, we set out the headline figures in Section B at EF 130 to 134. Now, as the court can see, and if the court doesn't mind, I'll just give a very brief overview of what has occurred. The patient experience phase of the inquiry has been completed, with contributions from 62 witnesses giving oral evidence. 28 statements have been read, and there have been contributions from 16 others whose accounts fell outside the time frame of the terms of reference. The inquiry has also heard from around 35 witnesses about the relevant laws, organisational structures, policies, practices, procedures that were in place at the time of the terms of reference. And the inquiry is currently hearing from staff witnesses. There is also then a clear plan in place to hear evidence in respect of 10 final organisational modules, and it's hoped that those modules will complete the inquiry's hearing of the oral evidence. I should say, for completeness, that there's been an unavoidable change in the timetable due to unforeseen circumstances, and we are now targeting the end of October for completion of oral evidence rather than the end of June. Now, as regards the parallel criminal proceedings, the court will be aware from the appellant's case that there has been an arraignment on several counts, but a date is not yet fixed for trial in the Crown Court. And the appellant in this case is one of 8 defendants currently before the Crown Court, but further prosecutions may follow in respect of alleged abuse at the hospital. The Police Service of Northern Ireland has submitted further evidence files to the Public Prosecution Service. The police investigation, which has been described as the largest adult safeguarding investigation in the UK, is not yet complete. So it can reasonably be anticipated that other prosecutions may follow on from the tranche of cases that is currently before the Crown Court. And that is important, I think, when one comes to look at the potential consequences of the exercise of the power. It's also worth noting, I think, that the protective measures adopted by the inquiry to guard against the risk of potential prejudice to criminal proceedings have continued to be applied and developed as the inquiry has proceeded. The learned judge at first instance summarised the various measures at paragraphs 83 to 104 of the judgment, and for the record, those relevant pages are EF 235 to 241. Now, Lady, my Lords, I'm not going to revisit those measures in any detail for the purpose of the present appeal, but it's important to note that those protective measures haven't simply remained static between the time when the case was before the court and the present. And just to give two examples of that, there's a reference to a memorandum of understanding that the inquiry agreed with the PPS and the PSNI. The first version of that memorandum of understanding appears at EF 1095, and the MOU is now in its third iteration, following on from ongoing engagement with PSNI and PPS to fine-tune the arrangements that are required to guard against potential prejudice. It was first published in March 2022. There was a second version in December 2022, and version 3 dates from October 2023. So there has been an incremental attempt, if one can put it like that, to deal with the challenges presented. For example, one of the changes to the second version of the memorandum of understanding that's not in the papers was the introduction of a formal mechanism for the disclosure of statements to the PPS, who are not core participants in the inquiry, in order that, if necessary, the Public Prosecution Service can make applications for restriction orders to the chair. And the second example actually relates to restriction orders themselves. I think at the time that the Court of Appeal gave its judgment on the 11th of October 2022, there were 9 restriction orders. There are now 50. There have been 6 orders made since the written case was lodged in February, and the majority of those have been granted on the application of the PPS and the PSNI on the basis that they're necessary to guard against potential prejudice in the criminal context. Every effort has been made to hear evidence in public, of course, but where necessary, restrictions have been imposed, for example, on attendance at sessions, on reporting of evidence, and on publication of transcripts. Now, for the purpose of addressing the relatively narrow point statutory interpretation of the court, it's not necessary for me to drill down in detail to the inquiry's work, but suffice to say, since this case was last before the court in Belfast, the inquiry has progressed significantly and has continued to deploy the protective measures that were endorsed by the court at first instance and in passing by the Court of Appeal. Now that leads me on to my second stage, which is to make some observations on the importance of context for the purpose of addressing the questions before the court. I'm drawing attention to the background for a specific reason. The inquiry is at a reasonably advanced stage of proceedings. Criminal proceedings, viewed in their entirety, are, relatively speaking, still at an early stage. The Section 13 power can, of course, be exercised at any time. So while the inquiry moves forward and the criminal proceedings move forward, the potential exercise of the power within Section 13 remains constant. And when considering which of the two competing interpretations Parliament intended when Section 13 was enacted, we say that it's important and indeed necessary to to have regard to this context. And in the written case, at paragraph 78, we invite the court to consider the potential exercise of the power through a contemporary lens. Let us assume for a moment that the question of suspension were being raised for the first time in March 2024. So the current state of affairs facing the Minister would be as follows.
Why is that relevant to statutory interpretation of Section 13?
Well, my Lord, the relevance is this. This provides the court with the actual context in which the power could potentially be exercised in this inquiry and indeed in other inquiries. When one is considering the nature and scope of a statutory provision of this kind, and when one is trying to get at the purpose of the provision, the objectives of Parliament in enacting the provision, we say that it's very important to understand.
What was the purpose of Parliament in enacting the provision?
The purpose of Parliament in enacting the provision, we say, was to confine the circumstances in which an inquiry should be suspended to circumstances in which that is truly necessary. That it's only in extreme circumstances that resort to this power should be had.
So this is your paragraph 79, is it? That effectively necessity, against that background, you would say makes perfect sense, as against
that's
any alternative.
Yes, indeed. My Lord, the point is that it's very easy sometimes to take the provision out of context and study it from the perspective of a purely academic exercise. But what we think our submission does is to provide the court with a reasonable example of the kind of circumstances in which a minister may be called upon to invoke the power in Section 13. And by considering that context, the court can have some understanding of the circumstances that Parliament itself may have had in mind when the provision was being enacted. Now, I just want to develop this a little bit for the court's assistance, because I think it's important to understand this background before considering the potential contemporary exercise of the power. Inquiry panel, administrative teams, solicitor teams and counsel teams have been in place for 2.5 years. The inquiry has been in operational mode for that period. It's been at hearing in dedicated inquiry premises, on and off for around 19 months. Multiple documents have been produced to the inquiry and remain subject to ongoing assessment. As I've mentioned, many witnesses, over 100 in fact, have given evidence. A significant number of those witnesses have been family members of vulnerable patients, or indeed former patients at the hospital. And the court will be aware from the written contributions of the notice parties, in this case of the desire of those affected by the inquiry, for the inquiry to proceed without interruption to its conclusion. The criminal trial of 8 defendants is pending, with other files under consideration and a large-scale criminal investigation ongoing. There are finely calibrated arrangements in place within the inquiry to guard against the risk of prejudice in the criminal context. The capacity of the inquiry to coexist with the criminal proceedings without resulting impingement on Article 6 rights has been judicially endorsed. The inquiry has in place a clear plan for completion of the evidence. And getting back to the point that I alluded to earlier, having regard to the open nature of the investigation, any suspension of the inquiry to allow for the completion of criminal proceedings in this case would literally be open-ended, to borrow the phrase used by the learned trial judge. That is the actual context that would be faced by the Minister contemplating the exercise of
Aren't all these very powerful reasons why the Minister should not suspend the inquiry, whatever the test, whether or not there's a test of necessity? I mean, they're derived from the particular circumstances of this inquiry, which I accept could well be the case with other inquiries.
But we acknowledge that there will be circumstances in which an inquiry can be suspended, but our point is that the factual context of this case, which could well be typical.
But my point is, these are all, as I said, highly relevant factors for a Minister to take into account in making a decision to suspend, whether or not there is a test of necessity.
But we say, faced with two choices, when one's interpreting the legislation, does one interpret the legislation in such a way as to enable the Minister to consider suspension where it may be desirable, for example, or he may think it may be reasonable to suspend the inquiry, or does one read the statutory provision in such a way as to consider that?
I mean, I suppose my only point is, in determining whether it's reasonable or desirable or highly desirable to suspend, the Minister would have to take into account all these circumstances, which might, well, in many or most cases, make it unreasonable to suspend.
Possibly, yes, but the question is why the Minister such flexibility within the wording of the statutory provision? Why not impose a test of necessity, as we say has effectively been imposed by the provision in section 13.1.
And you interpret necessity as being absolutely essential, is that right?
The normal meaning of the word, yes, something that is required, my Lord, but it is actually necessary, not that it's perhaps a good idea or desirable. We say that the Minister must regard it as necessary to suspend. And I think what the factual scenario does is it illustrates the potentially far-reaching implications of suspension. We address these in section Part E of the written case. But I think it's perhaps, again, worth highlighting some of the consequences that would flow from a decision to suspend. Let me give 6 examples with the court's permission. The inquiry's operation would have to be significantly scaled down in the event of this interruption to the hearings. Section 13.6 specifically provides that a panel member may not exercise any power under the Act during the period of suspension. Second, considerable uncertainty would be generated. As I indicated, such is the nature of the ongoing investigation that the suspension would literally be open-ended. Thirdly, there's actually some risk that if suspension extended for years, as would probably be necessary in the context of this case, it would be virtually impossible to reset the inquiry with the same inquiry personnel.
Well, I come back to the point that my Lord Richards raised. That is, all these factors can be taken into account in relation to a decision to suspend, regardless as to whether it's a necessity test or whether it's not.
They could be taken into account, my Lord, but we...
Or would require to be taken into account.
Yes, but we say that viewed in this context, the imposition of a test of necessity in section 13 makes perfect sense.
Yeah. Okay.
Fourth example, the expectations of those affected would be put on hold. Fifthly, the public interest in finding answers would be put on hold. And finally, the very important forward-looking aspect of the inquiry's work would be affected by significant delay, because the inquiry is not only examining the issue of abuse at the hospital and how that came about, but one of its core objectives is to ensure that such abuse does not occur again in the hospital or any comparable institution. So, suspending an inquiry would have an inhibiting effect on the inquiry's ability to inform and improve future practice in the field of caring for vulnerable persons with severe learning disabilities. And again, this inhibition would apply to other inquiries as well. So, my lady, my lords, it's our submission, it's important that the court should analyse the wording of section 13 with the above context in mind. I think, as Lord Stain said in Ex Parte Daily, in law, context is everything. And we say that the context makes the interpretation that was endorsed by the Court of Appeal a more attractive one than the alternative advocated by the appellant. So that leads me on to the third stage within my submission, which was to return to the statutory wording. And again, given the context that I've outlined, it's hardly surprising that the inquiry favours the view that the test of necessity across section 13.1. I'm not going to go over all of the ground that the court has heard from the appellant and the respondents. One point that hasn't been made yet is that section 13 is actually a single sentence. We agree with the Court of Appeal that it naturally reads as one question that must be answered. It requires one single coherent decision. And repeating my point, we say the context of the present inquiry illustrates the good sense of the application of a test of necessity. It certainly can't be said to produce any absurdity. In fact, having regard to the scale and effort required to establish an inquiry and the public interest in its outcomes may be somewhat surprising if Parliament had intended to permit the Minister a rather broader latitude in making the call to suspend. A further point that perhaps hasn't been spelled out is that if Parliament had intended this to be a two-stage decision-making process, as advocated by the appellant, it would have been very simple to spell that out in the legislation. The timing of suspension issue could easily have been the subject of an entirely separate clause or even a separate sentence. There's an interesting passage in the appellant's application for permission to this court. It's at paragraph 36 of the application, and the page reference is EF page 24. And the appellant says that section 13.1 can be broken down into two parts, relating respectively to the suspension and the timing of suspension. As a matter of fact, however, it is not broken down into two parts. And we would ask, why would it be broken down, read as a single entity, grounded in necessity? It makes perfect sense. So, my lady, my lords, the central submission on behalf of the inquiry is that the Court of Appeal is correct. The inquiry essentially agrees with the respondent on the issue of interpretation, but we say that the textual argument is strongly reinforced by the contextual matters that we have brought to the Court's attention. Final and brief point was with reference to the analogy that has been drawn between section 13 and section 1 and 14. And my lady, my lords, it's clear that section 1 of the Act is quite deliberately couched in very broad terms. An inquiry can be set up even where events are capable of causing public concern. An inquiry can also be set up even where there is public concern that particular events may have occurred. Now, it's somewhat difficult to see how a test of necessity would ever have been appropriate in that context. As for Section 14, we say it can readily be understood why Parliament would not have imposed a test of necessity to the decision to end an inquiry. Actually, looking more closely at the explanatory notes to Section 14, which the court has looked at briefly already, that's at EF 1186. And it's actually quite a lengthy exploration of the possible range of circumstances in which an inquiry might be brought to an end. I'm not going to read through the whole paragraph, but in the middle one finds the example, other events might occur which also need to be investigated, and it may be more appropriate to set up a single wide-ranging inquiry, perhaps with a different panel. It seems to me that's
we are in the middle of paragraph 27,
yes,
at page 1186, the passage beginning, other events might occur.
Yes, indeed. Yes, that's correct. And it's the explanatory note on section 14 itself. And the example I'm looking at is other events might occur which also need to be investigated, and it may be more appropriate to set up a single wide-ranging inquiry, perhaps with a different panel. And then they go on to give other examples, such as something might happen, such as a fire or the death of a witness, which means that inquiry will no longer have access to the evidence it needs to conduct an effective investigation, and it may no longer be.
Well, I'm sorry to interrupt you, but these are the notes on the Act.
Yes.
But the notes on the bill are in different terms, at page 1481.
Yes, my Lord, well, I'm actually looking at the notes on the Act itself.
Well, I'm not sure that explanatory notes on an Act which has received royal assent has ever been considered to be admissible as an aid to construction, because clearly Parliament didn't have them before them when they enacted the legislation.
Well, my Lord, I think whether or not one is to place reliance on the...
Well, this is no more than the government's commentary on an Act which has been passed.
Yes, but what
it has no weight at all.
But what it does, I think, my Lord, is it illustrates that the potential circumstances in which...
No, I'm sorry. We're looking at something which is, as I say, the government's view of what the Act says after the Act has received royal assent.
My Lord,
if explanatory notes have any legitimacy at all as an aid to construction, it is because they were before members when they were considering the bill.
Well, my Lord...
Is that not right?
Well, my Lord,
is there any authority for looking at explanatory notes to an Act as an aid to construction when they differ from...
I think you'll find that Binion makes that distinction.
Yes, my Lord. Well, I think, my Lord, if I can put it like this, rather than placing specific reliance for the purpose of interpretation, I'm simply saying one can understand generally why flexibility is needed when consideration is being given to whether or not an inquiry might be ended, because there will be a myriad of circumstances in which that might be appropriate, albeit not necessary. But the difference between termination and suspension is that with suspension, the exercise of the power involves no acknowledgement whatsoever that the rationale for establishing the inquiry has changed in any way. So, in other words, there's no recognition whatsoever that something different needs to be done. The commitment that was given at the outset to the establishment of a public inquiry and the completion of a public inquiry remains intact. So we say actually that it's perfectly understandable, again viewed in that context, that a test of necessity should be applied to Section 13, but not necessarily to Section 1 or Section 14. So I think essentially what we say is there's nothing faintly absurd.
Yeah, well, Mr. Cole gave the example of a party having as part of its manifesto that it will shut down an inquiry.
Yes. Yes. So my Lord, there's not. Well, let's put it like this: there's nothing absurd about the presence of a test of necessity in Section 13 and its absence from Sections 1 and 14. My Lady, my Lords, those are the inquiry submissions. An inquiry requires a measure of certainty to proceed confidently and effectively with its work in the public interest. And we say it can reasonably be inferred that Parliament had that need in mind when enacting Section 13.1, and the application of the test of necessity to Section 13.1 makes logical sense. So for all of those reasons, my Lady, my Lords, it's our respectful submission that the appeal should be dismissed.
Thank you, Mr. Doran. Mr. Larkin.
I'll group my reply perhaps under four heads. So, firstly, considering the reliance on the Hansard material, it's quite clear we say that that's of no assistance whatsoever. EF 1428, there is a reference to, as my noble friend has explained. So the Speaker is purporting to reproduce what has been said earlier. Now, one speaks always subject to correction, but there is no trace in the debate, at least the debate as put before the court, and as we can find, of those words having been said. And if one thinks about it for a moment, of course, that would be the fons et origo of the view by someone who, in any reckoning, had a subordinate position in the government hierarchy, who wasn't the main promoter of the bill, so he would defer to her. And yet one doesn't find it anywhere else. So this is a classic example of the kind of material which is frequently brought forward relying on Hansard, which actually sheds no illumination whatsoever on the point. Secondly, and with apologies and with great gratitude, may I adopt the expression thrown out by my Lord Richards in exchanges with learned friends apropos of the explanatory notes when he said that it was, I hope I've got the quotation correctly, a rather muddled picture. And we are in entire and respectful agreement with that characterisation. Thirdly, my little friend, Mr. Doran, on behalf of the inquiry, entirely understandably, from the perspective of the inquiry, painted a picture of a succession of bad things occurring if the inquiry were suspended, some six in all. It's entirely understandable that he should advance that submission. Of course, all of those will occur in the event of the inquiry being terminated. Indeed, they will be aggravated in every single instance if the inquiry is terminated, and there is professedly no limitation based on necessity on termination. But there's a more fundamental point in relation to a submission on that matter. It was an unstated premise, I invite the court to conclude, of that submission, that the Minister was really to be regarded as a potentially errant child or as predisposed to irrationality unless she or he was restrained. Now, there is simply no basis for that. Parliament does not operate on such an interpretive presumption, and such a presumption is, we say, effectively belied by the open-textured existence, the professedly open-textured existence of Section 14, because Section 14 would surely be the provision that could be wielded by a mischievous minister if one were to be posited. And one knows simply from the experience of this statute in operation that inquiries have not been controversially or willy-nilly brought to an end. And finally, my lady, my lords, we invite the court to mark this. In exchanges with my Lord Burrows, Minister Mr. Call was disposed to accept that there would have to be some rewriting, some extraction and some reintroduction of the reference to a period. And we say that's right, and that is, we say respectfully, fatal to the respondent's case. When we made the submission that the adjective necessary qualifies only the noun period, there was no attempt to answer that. And when we said that there was a replacement of the words, the reference to the period, which is a reference to chronology and temporality with a condition of general conditionality, there was no answer to that. And we say that is also separately and secondly fatal to the respondent's position. So for all those reasons, we respectfully invite the court to allow the appeal and to make appropriate declaratory relief. Lady, my lords, unless it can be of some particular assistance, those are our submissions in reply.
Thank you, Mr. Larkin. We're very grateful to all counsel and solicitors in the case, and we're grateful particularly to counsel who have addressed us this morning for complying so precisely with the very tight time limits which have been imposed. We're very grateful to you. We're also very grateful to those who have assisted you and those who prepared the case for the hearing this morning. I should also say, because we're very mindful of the submissions that we've received from the interveners, of which we will take full account. We will take time to consider our decision. The court is now adjourned. Thank you all very much.